Before I commence with my presentation, I would just like to ask you, in fact, to tell you that you're more than welcome to ask me any questions, but please can you just save them for later until at the end of my presentation, during the lunch break, yes. But I'm more than welcome to take your questions. It's just that I have a limited amount of time that has been allocated to me. Today I would like us to discuss using contracts as a dispute avoidance mechanism. Before we commence with my presentation, I would just like to share with you a true story. It was a case actually that was decided in Canada. So two parties had entered into an agreement. They got somebody, whether it was an attorney or not, we do not know, who drafted this contract for them. But then in a material clause, they put the comma in the wrong place. As a result of this now, it changed the entire intention, common intention of the parties. Now when it was interpreted, it was the wrong interpretation. Now this led to disputes. And eventually it went to court, and the court ordered that one of the parties had to pay the other party $1.5 million, all because of a comma. It happens everywhere. It happens in South Africa as well. Why? Because the main problem is how the contract was drafted. This is what we're going to be discussing today. Okay. Sorry about that. So using contracts as a dispute avoidance mechanism. In order for us to understand how to avoid these disputes from arising from a construction contract in the first place, we need to define what is a contract. Simply put, a contract is when two parties or two entities, let me put it that way, come together with one objective. The same intention that, let's say for example, we want to build a bridge or we want to build a mall with an engineer, for instance. This is what we want to do. It's legal, it's a written agreement, we sign, there's your valid contract. Now, it's common for us to find in a contract provisions being made for a dispute resolution clause or the choice of law that will have jurisdiction over this contract. But the problem is, as much as they make provision of this, because this would be a result of a dispute, a breach that occurred. Now, and then they will say that, okay, fine, then you can maybe refer it to an arbitrator to resolve this dispute. But the problem is that these contracts are not drafted in such a way as to avoid these disputes from occurring in the first place. So let's discuss the three causes of disputes in a construction project. Number one, the problems with the contract. Secondly, poor management and leadership, and the circumstances beyond the parties' control, the unknown. The first problem is that a contract is supposed to be drafted in such a way that it clearly conveys or expresses the parties' expectations regarding the payment and the performances. The contracts must clearly identify the rights and obligations of parties in all stages, from the developer stage, to the designer stage, to the contractor stage, subcontractor and supplier, etc., etc. Now the problem will be if the scope of work in the contract is ambiguous, which means it's vague or it's incomplete, then this will create problems because the parties are not clear as to what are my rights and responsibilities in terms of this contract. So what is the solution? Let's say, for instance, you already have a contract in place between you as the employer and the contractor. Get an attorney to review that contract of yours, or in the first place, get an attorney, a qualified commercial attorney, to draft that contract for you in order to eliminate errors, omissions, ambiguities, and risks. Secondly, poor management and leadership. Now, when you're building, for instance, this bridge of yours or this mall, there will be different teams that will be involved. It's not just you as a contractor and employer. You will have your supplier, your engineers, you know the whole process, the different teams that are involved in building, in a construction project, for instance. So now, because you have these different teams, people in place, people are different, and some people, they lack sense of urgency. Now this will result in unnecessary delays, or there's lack of communication, which means the other parties are not updated about the progress of the project, for instance. So, which means now that there will be there are no conflict management skills. What do we need now in each of these teams, in the leadership? We need effective management of the product in order to avoid these conflicts that may lead to breach of the contract, which may later lead to a litigation process. Thirdly, circumstances beyond the parties' control. Now, let's say, for instance, you're building this bridge, and then there's an earthquake or a flood, or there are labor strikes, unusual severe weather, or the conditions of the site. Now, these are the events that the parties did not foresee these events, and they are beyond their control. What happens? Now you've commenced with this project, and then this is what happens. The flood destroys the bridge. Now it will result, for instance, in the contractor requesting for more money or time. So what is the solution? You need to include the following clauses in your contract when you draft them. These are the fundamental clauses in a construction contract that need to be included in your agreement. Number one, we have force majeure. Now, in this clause in your contract, this will stipulate that neither in the event that, let's say, for instance, a flood, you list all the examples, the flood, war, earthquake, labor strike. These are circumstances beyond the parties' control.